Good afternoon and good morning, everyone. I'm Carl Zwisler with the Great Plant Moody. Welcome to New Risks of Anti-Poaching Requirements in Franchise Agreements. This is a program that's designed to last for 30 minutes. And during the program, we are going to touch quite a few issues, including an overview of developments relating to anti-poaching. We're going to explain something about the cases that have been filed against franchisors and the theories that have been used and what the defenses to those theories are. We're going to discuss the viability of those claims, and we're going to talk about what franchisors should do, should not do, and what they should think about doing in response to everything that's going on. We're going to talk a little bit about the Washington Attorney General's Civil Investigative Demand, and we're going to talk about, very briefly, Senate Bill 2480 that was just introduced last week. This is one of a continuing series of webinars that the Great Plant Moody Franchise Practice Group has presented. The next one will be on May 30th, when we're going to talk about the General Data Protection Regulation from the EU, and that privacy rule applies to any personal information that is collected from an EU resident. So make sure that you come back for that, because that becomes effective on May 25th. During the program, we will not have time to take your questions, but if you do have them, we ask that you write them and send them to us, and we will try to compile answers to the most general questions, the ones generally applicable, and we will post them on our website. At the conclusion of this program, within about 48 hours, the entire audio presentation, as well as the slides, are going to be hosted on the Great Plant Moody website, so you can come back and look at that, as well as some of the other materials that we will be talking about. With me today during the presentation is Quentin Wittrock. Quentin is an elite antitrust litigator in the Minneapolis office of Great Plant Moody, and he focuses his practice on antitrust franchising and distribution law. Quentin is also the editor-in-chief of the GP Memorandum. I'm Carl Zwisler. I have been practicing franchise transactional law for many years, and I'm based in the Washington, D.C. office of Great Plant Moody, and I'm one of the people responsible for writing some of the provisions that we're going to be talking about today. Well, first of all, what are we talking about? Someone saw our promotion and said, what is anti-poaching? Well, the best way to answer that, I think, is to take a look at the definition provided by the Washington Attorney General. And he said, provisions in a franchise agreement limiting a franchisee's ability to solicit or hire workers from another franchise is an anti-poaching agreement. So a limitation on an employer's right to hire somebody else's employees. I'm going to refer to those as APAs, anti-poaching agreements. That's what an APA is. Why are we talking about APAs right now? And Quentin, if you review what's been going on with this issue for the last few months, I think everybody will quickly understand.
Yes, this is a situation where a lot of people have gotten into the act. It started with the Obama administration in October of 2016 said that they were going to be enforcing antitrust law through the Department of Justice and the FTC, having to do with the hiring or non-hiring of people pursuant to these kind of no poaching or no hire clauses. As is often the case when the government speaks, the plaintiff's lawyers listen, and there were class actions filed next in the McDonald's case and the CKE case in Illinois and California, respectively. Then an article was published in the New York Times, Why Aren't Paychecks Growing? A Burger King clause offers a clue. And this is a further look into the effect of no hire clauses or APAs. Then there was an article, an economics article about it, and followed by 2 more class actions. So by our count, there are a total of 4 class actions ongoing right now. Then, just recently, in 2018, the Department of Justice antitrust chief, this is now, of course, under the Trump administration, this is Trump's appointee, said that they're preparing criminal cases to address anti-poaching agreements. We haven't seen any of those yet, but they said they're preparing them. Followed by, last month, the Washington Attorney General issued these Civil Investigative Demands that franchisors cough up their information regarding how much they use the anti-poaching agreements. Then, as the politicians begin to get more into the act, the Booker-Warren bill, Senate 2480, came out just last week. So, and also Booker and Warren, we have learned, wrote a letter to the Antitrust Division of the Department of Justice saying, hey, how about that enforcement you said you were going to be doing? How are you coming on that? We want a full report. How are you enforcing this like you said you were going to? So that's the status that caused us, and some of these things happened after we came up with the idea of having this webinar and publicized it. So this is a very timely topic. Carl, why don't you go through, as the transactional lawyer among us, what are these clauses and the variations? We have them on the next few slides.
Sure, and I think most of you can read this, so I'm not going to dwell on them much, very long. But generally, the clauses prohibit hiring or recruiting any employee or just store-level managers. So one is obviously a broader type of restriction than another. All of them apply to recruiting or hiring someone during the term of employment. Most of them also prohibit hiring an employee for a period of time after the employment ends. And you can see there's quite a variation in the amount of time. Every one of the restrictions that we have looked at applies to both all franchise-owned and all company-owned outlets. And the vast majority of them apply to outlets situated anywhere. We found one exception, there are probably more, that limit the application of the APA to 10 miles from the location which is being rated. In some cases, we've also found that the APA applies to employees of the franchisor's affiliates outlets, and we'll talk a little bit more about why that's problematic later. The prescribed conduct includes recruiting or soliciting, or just hiring an employee, or hiring an employee, a partner, owner, or director. So some of these are quite broad. I'd like to pay particular attention to some additional requirements that we found in some of the cases. In one, each employee, not just management employee, but each employee was required by the franchise agreement, the franchisee was required by the franchise agreement to sign a non-compete agreement. In many of the systems that were cited in the economics article, the franchisors either requested or required job applications used by franchisees to explain the prior employment history of the applicant in the franchise network. And we found several cases where franchisees were named third-party beneficiaries of the APA, giving them the independent right to sue their fellow franchisees for violations. The remedies for the violations are typically either termination, arguably damages, and in several cases we found liquidated damages provisions, and $50,000 plus attorney's fees exist in one of the class actions that's being litigated. You may have seen this in the information we sent around to promote this webinar, but according to an economics survey that was conducted for Kruger and Ashenfelter, who are a pair of Princeton economists, they retained Fran data to conduct a survey, and they found that of those companies that had 500 or more units, 58% had an APA. And that same article that is cited here identifies 91 of those franchisors that had some form of APA. On this next slide, we see a breakdown by industry sector of where the use of APAs is the most common, and it's pretty clear that quick service restaurants has the highest proportion of use of APAs. But if you look down the chart, you see that some people are using it in almost every industry. Quentin,
so I thought I'd talk a little bit about the legal theories that are being used to challenge these, so what we'll call anti-switching agreements or APAs. The primary one, of course, is the Sherman Antitrust Act. Section 1 in particular of the Sherman Antitrust Act prohibits competitors from agreeing amongst themselves or colluding to restrain trade. So I reviewed the 4 class action complaints, and they're all still pending, by the way. None of them have resulted in any judicial decisions as of yet, to our knowledge. But this next series of slides, I think, demonstrates what the plaintiff's lawyers are getting at, and you should, by these illustrations, see the essence of the antitrust analysis that at least is likely to play out in the court decisions. First of all, in the antitrust law, Sherman Act makes illegal, as I said, agreements or collusion among competitors to restrain trade. And here in this slide we have franchisee A, B, and C, and they each own one store. And if the 3 of those franchise owners in the same geographic market met at a local franchisee meeting or just knew who each other were and emailed or phoned each other, had a conference call, and agreed not to hire each other's employees, that would be a horizontal agreement. And that would be, on its face, a violative of the Sherman Act, Section 1, at least in the view of plaintiffs' lawyers, just as if A, B, and C agreed among each other to fix prices. They would be deemed to be restraining competition in the employment market. So then, when the franchisor gets involved, it's different. The franchisor, through its independent franchise agreement with A, B, and C, tells them, all of you agree with us, the franchisor, independently, that you will not hire from other franchisees in our same system. If they do that, that, as you can see by these arrows, is somewhat of a vertical arrangement and seems less collusive amongst the franchisees themselves. In the next slide, however, it gets complicated because now the franchisor has bilateral agreements with the franchisees that say that not only can you not hire from other stores, franchisee, you can't hire from us, the franchisor. So we, the franchisor, won't hire away from you. And those are terms in the franchise agreements. So now this becomes more, in the plaintiff's lawyer's eyes at least, of a demonstration of collusion not to hire amongst competitors, and they're competitors in that they could all be competing to hire the same people and to employ the same people. The next slide causes it to get even more complicated because the plaintiff's lawyers point out that sometimes here there's a 4th store. Store number 4 in this scenario is owned by the franchisor. So now if the franchisor has a franchise agreement with A, B, and C that says you will not hire from any other store in our system, the franchisor is agreeing in effect with the franchisees that they won't hire from the franchisor either. And so then they are deemed to be competitors. This is a situation that historically has been referred to as dual distribution, when the franchisor or supplier operates at the same level as the franchisees or dealers. And there's a separate analysis for that. We don't know how it will play out in this situation. The plaintiffs describe these various charts that I've had and the permutations of them as all a big scheme to reduce wage competition. That, of course, is a cultural hot button, that there are the haves and the have-nots, and the people arguing on behalf of the workers are using very demeaning language toward the employers, the franchisors, and the stores in this situation. If you read these complaints, they're full of spurious allegations about the CEO of the company makes hundreds of times as much as the workers in these stores who are being repressed and restrained from competition. This is deemed to be a horizontal agreement in violation of the Sherman Act because of the three things that we've already talked about, because there are company stores involved, or because the managers of the franchisor are off limits as well as the franchisee, and because these agreements are mutual, not to hire from each other.
Let me point out that this is the allegation of the plaintiffs. No court has found this, right?
Of course, yes. And this is my review of the complaints that the plaintiffs' lawyers have filed in the case. This is the arguments that they are making. And then they seem to take great relish in making the argument that this no joint employer language, which has been finding its way more and more into franchise agreements, somehow is further evidence that supports the plaintiffs in the cases. And they do that by saying that this language always says that these stores are independent actors and they hire who they want, and the franchisor is not involved in their employment practices. The plaintiffs' lawyers like to say that that is a falsehood, and that it further demonstrates the bad faith of the franchisors in constructing this system, which, as I said, they allege is designed to keep workers from getting their just pay. The defendants, of course, have arguments as well, and again, we don't know how these will be viewed because they have not resulted in any court decisions yet. But the franchisors point out that no court has ever, to this day, ruled a no-hire agreement to be illegal, or at least not per se illegal under Section 1 of the Sherman Act. The defendants' lawyers point out that franchising by its nature is a vertical relationship, and that no-hire agreements should be governed by the rule of reason. And I won't try to get you antitrust CLE credits here for this presentation, but in antitrust law, vertical arrangements normally are governed by the rule of reason, and the rule of reason is more lenient because the focus is on intra-brand competition, the focus of the antitrust laws. But anyway, the per se rule of illegality under the Sherman Act is the opposite of the rule of reason, and the defendants argue that the per se rule doesn't apply and has never applied in the franchising context. But in the situation where we are, where we haven't gotten court rulings on this, we don't know how these cases are going to end up. And so what you have as a franchisor is a set of legal risks ranging from liability for trouble damages. And when we're talking about a class of plaintiffs, all of the workers in your system, if their wages were depressed by even several cents apiece per hour because of this depression of wage competition, because they can't go from store to store to try to get a better wage, you can see that the numbers could add up. And three times.
They certainly do, because they go back 5 years, and in the restaurant quick service industry, for example, the estimated annual turnover rate is 50%. So you can count the number of employees who may have been employed in a single restaurant over the course of 5 years, and then just multiply whatever the damage amount is, and you can see these can be big numbers very quickly.
And if you've ever been involved in a class action lawsuit, I know that you are aware that the attorney's fees are a big factor in those cases. And it's not only paying your own attorneys. The plaintiffs under the Sherman Act are entitled to recover their attorney's fees if they prevail. And often the settlements in these cases, as is famously borne out in the subway settlement about the foot-longs that weren't a foot long, the attorneys often get all of the money in these cases. And to pay the attorneys of the plaintiffs to settle these cases often requires a great deal of money. So there's bad publicity, and there is, of course, distraction from the business that comes along, and those are risks as well. Carl, why don't you talk about the Washington Civil Investigative Demand?
Thanks, Quentin. In the second week of February, after we had already scheduled this webinar, we learned that the Washington Attorney General had issued requests for information from an unknown number of franchisors. We think the companies that have been receiving the request are in the restaurant industry. We're not entirely sure. We're representing a couple of companies in that industry here in the CID. But let's talk about what's been requested. The Washington Attorney General wants each franchisor who receives the CID to state whether any franchise agreement signed during the last 5 years in Washington contains an APA. If there is an APA, the AG wants to know the reasons that the franchisor has one, and if the franchisor has changed or eliminated the APA during the last 5 years, the franchisor is required to present the explanations for the change or elimination. And of course, each franchisor is required to identify each restaurant that it owns and a franchisee owns in the state. I placed a call to the Assistant Attorney General, who's responsible for this, explaining we were having a webinar and asking for information, and he refused to tell me anything, saying that it's the policy of his office not to comment. So we don't know whether this is just the beginning of the investigation, whether NAG, the National Association of Attorneys General, is going to take this up and make this one of their projects, or whether other state attorneys general will pick up on it. We don't know what the result of this will be. We suspect that the Washington AG would like to be able to say that he has ended APAs and franchise agreements in his state, but we really don't know what's going to happen. But we do know that this information that is going to be provided in response to those could be very important to the franchisors who respond. So why should franchisors be concerned? Well, first of all of the responses must be truthful and not misleading. If they are misleading, that can result in sanctions, which might be much more severe than any sanctions that might arise from having an APA. Secondly, and perhaps more importantly, the justifications and the reasons that franchisors give for doing what they've done are likely to bind franchisors in any litigation. These may be used in other cases, both public and private. So it's very important to think through and understand all of the implications of the response. Our colleague Eric Yappi has just published a law review article called The Unwelcome Phone Call Responding to Regulatory Audits and Investigations, and it's in this latest issue of the Franchise Law Journal. So if you've received one of these CIDs, you might want to take a look at that. Quentin, should franchisors drop or modify their anti-switching language?
Well, what I've been advising clients on this, and this goes back to 2016 when the issue first started to raise its head, is to evaluate, why do you have this? What is the purpose of this clause in your franchise agreement? Is it a remedy without a problem? Is it something you're even enforcing? And to really take a deep dive into the history, use, and purpose of the language. Then the wording of your agreement should be evaluated. And is it horizontal by nature, in that you have a lot of company-owned stores, and this prohibits franchisees from hiring employees away from your company-owned stores? Or does it pit you and your franchisees as people who can't hire from each other, even at the corporate level? And is it overly restrictive in scope and in geography and all the other ways it could be overly restrictive? And then, if you have determined that it is not absolutely necessary, or that it is horizontal more than it needs to be and it's overly restrictive, then I think you should change the clause that you have in your new franchise agreements going forward. Still raises the question about, what do you do about all of the agreements that are in place?
All right, let's talk about some issues that raise additional risks. Quentin, maybe you can help answer this question. Some agreements have third-party beneficiary rights for franchisees to sue other franchisees to enforce the agreement. Do you think that creates an additional risk of horizontal behavior?
I think that there is a possibility. I haven't really seen it come up much in the cases that have been filed so far, let alone see how it's going to play out. But personally, I'd rather have the franchisees suing each other. I don't think they would, first of all, if somebody got hired away from them. But I like anything from a franchisor's perspective that involves the franchisor less. So that's my first comment on that.
Second provision that we see in a lot of these is that the provision can be waived if the targeted employer consents. But doesn't the act of one franchisee calling another, asking if he'll waive the requirement, set up a consent situation that could be horizontal restraint?
Yeah, what's illegal under the Sherman Act Section 1 is an agreement in restraint of trade. And so if the two franchisees are talking on the phone and now they have an agreement among themselves that this person won't be hired by franchisee B, that seems like it is more dangerous under Section 1 of the Sherman Act.
All right. Well, many of the franchisors that we're talking with today have had this language in their agreements for decades, or at least for many years. It's possible that many franchisees depend upon it and feel it's important. So when many changes are made in franchise agreements, it's common for franchisors to involve franchisees in the decision-making, at least in the analysis of what the problem is. What are the issues that we should be concerned about if a franchisor consults with its franchise advisory council about making a change to an APA?
Well, if there's a consultation with the franchisees and then the decision is made to keep the no-hire agreements or the APAs, then it makes it even easier for the plaintiff's counsel to prove that this agreement is part of a conspiracy and that they like the depression of wages that it causes.
Question number 4 here. We've seen some restrictions that apply to affiliates of the franchisor, which doesn't seem like a big deal, but in one of the cases involving Jimmy John's, the plaintiffs point out that Jimmy John's had just been acquired by Rourke that had about 10 other affiliates that were involved in the restaurant industry. So I suppose it would make sense if we have this no poaching from an affiliate language to reconsider that pretty quickly.
Yes, I agree with that. And then on the last one, in the interest of time applying to all workers, I think that that's just awfully broad to apply it to every 16-year-old kid that works in your store, that he can't be hired away and can't go to work at another location that's closer to his house or to his school or whatever it is. Seems like that's overly broad. To justify these kind of restrictions, you have to have training and a great deal of investment that you've made in the workers in order to justify why these restrictions make sense in your system.
All right, let's move on to our following category, which is how can we help you? First of all, if you'd like copies of Senate Bill 2480, we can make those available as soon as they're printed. They haven't even been printed yet. We've reviewed a draft copy, and we're not sure it's the final one. If you're interested in responding to investigations article, let us know. We can get you a copy of that. As I mentioned earlier, we are representing companies in the Washington investigation already, so we're available to share our insights into that if you need them. Finally, remember to send us your questions. To the extent they're general questions, we will do our best to answer them, and we'll post them with this webinar. Also, I invite you to contact Quentin or me or any lawyer in the Great Plant Moody Franchise Practice Group. We'd be happy to help you think through this. As you can imagine, dealing with issues of horizontality and verticality, the rationale for having a restriction or not having it or changing it are really individual decisions, and that have different ramifications within different franchise programs. So it requires a lot of individual thought. On behalf of Quentin, I would like to thank each of you for joining us today. I hope you don't have any problems with your APA. We're going to continue to track this issue, and we may be back to you with more information or another webinar if it's warranted. Thank you very much.
Thank you.